Just a few observations, and hopefully not to supplant the questions to come. I frankly think there's considerable continuity between the two administrations. It's a good thing, and to the extent there isn't, it's politics. It's understandable. To me, the real problems are structural and long-term. And let me briefly tell them what they are. First of all, forget about the war. Forget about sort of military implications. From a constitutional perspective, to have the Supreme Court, a working majority of the Supreme Court, and numerous lower courts move in the direction of the proposition that any time one of the political branches or two of them working together make a decision, no matter how discretionary, no matter how much predicated upon various difficult to quantify and ascertain by the courts matters. Anytime they make a decision that impacts individual liberty, that decision has to be subject to judicial review. Ladies and gentlemen, it fundamentally warps the separation of powers, would amaze the framers, and basically puts the judiciary in the final position of being the arbiter of everything else done by the two branches, because it's precisely because the judiciary's role is so dispositive that there are numerous issues that are not subject to judicial review, particularly discretionary exercises of power. And the reason, ladies and gentlemen, of an executive, after a few years of tremendous disenchantment with executive power, but early in our constitutional history, prior to the more perfect union existed, is because people understood quickly you cannot run things for legislature. And there's only one thing worse than legislature when you try to deal with things, and that's the courts. Now, the thing I find slightly depressing is, despite that fact, the people who are largely responsible for sort of driving this wave of litigation during the Bush years, instead of supporting the notion that you need to bring the Congress in to deal with some of those issues, are applauding the fact that the administration, it's the only criticism of the administration I'll make, the administration decided not to put up a new comprehensive framework for detention and other issues. I probably would have disagreed with some of their calls, but to say that we should do common law format judicial micromanagement, this is a good thing, is deplorable. Briefly about the district court litigation. Don't take my word for it. I already mentioned it. Go read an excellent study, not written by some Bush fans, but two very judicious fellows, including a guy who for many years wrote for Washington Post, Ben Wittes. It is appalling what the courts have done, and the fact that the decisions come out this way doesn't mean that they were wrongly detained. It means that exacting criminal justice style evidentiary and other burdens, surprise, cannot be met. In a battlefield context, especially at the time people were apprehended, they didn't know that was required. We're talking about on 7 or 8 key issues, ladies and gentlemen, not just evidentiary burdens, but what does it mean to be a member of Al-Qaeda? Okay? Or, my other favorite, even if you were a member of Al-Qaeda, can you have done something since you were detained that no longer makes you such a member? And all those 7 or 8 issues, there are 5 or 6 camps among the tiny universe of district court judges deciding it. It is a horrible way. It's even a horrible way for a common law system. Final point. Forget all the highfalutin constitutional stuff. Implications. Implications are basically this. The United States is out of detention and interrogation business. We're not taking people into custody. We're certainly not interrogating them, because despite the excellent job that Neal and others have done, even if the D.C. Circuit prevails, overturns Bates's decision in McCulloch, and the Supreme Court does not take the cert, the better view is anytime you take somebody in custody in the world, you better get the kind of forensic evidence that will be sufficient to hold the person, which in turn puts enormous stress on special operations people. Have you ever figured out how you're going to gather forensic evidence in the middle of a snatch and grab operation where the time on target is only a couple of minutes, and if you linger longer, you're going to die on your way out? It is tremendous. By the way, one of the reasons we're using so heavily drones is because we, frankly, in a situation where there was an opportunity to go in and grab a person and bring him back for interrogation versus killing a person, might as well kill him, because you're certainly going to be able to grab him. This is a horrible way to fight a war. It's very bad for our troops. And incidentally, all the shilly-shallying about where the battlefield is, the battlefield in this war, as in many other wars, is global. To really want judges to say, to hear that some of the people who were captured in Pakistan, ladies and gentlemen, were not captured on a battlefield. We can have a long discussion about where ICRC and some of our international friends come out on the definition of a battlefield. But just as a common sense matter, if you tell General Petraeus that the battlefield in Afghanistan is limited to the by the borders of Afghanistan, he'll tell you you're an idiot. We're talking about, Afghan-Pakistan theater. Al-Qaeda is not prosecuting this war in this way. And the worst case scenario, again, is we're talking about the migration, this obsession of a case-by-case judicial micromanagement to things beyond detention. Just mark my words, it sounds crazy, but we are going to have a FOIA push by ACLU for all the procedures, as I mentioned, that relate to how you put people on target lists. It's not enough that you fully brief this to Congress. We're going to be moving to the points where issues about what's permissible collateral damage, what's permissible target, where's the battlefield, are all going to be before the judges. And by the way, the question, what is the battlefield, is ready before the judges in the context of Boumediene and other things. That is a horrible way to fight a war, and this is indeed madness. It's unprecedented, and it really warps our constitutional system. I cannot say enough bad things about this.
If any of our other panelists have any comments that they'd like to make briefly before questions.
Just briefly, first of all, David is too humble to tell you that he wrote an extraordinary brief in the Bagram case on behalf of the Special Forces Association and Senator Graham. It's a really powerful brief that makes the argument that he just did, but in a long form. I've never seen the Special Forces Association take a position in a case before, and so I do commend it to all of you to take a look at. I just wanted to briefly respond to this notion that we brought the detainees outside of the theater of war and brought them to Bagram, and therefore they don't have habeas corpus rights. And again, this is just what our brief argues. Brief argues that that is basically legally irrelevant. I mean, the Eisentrager case that I told you about from World War II, the detainees they were captured in China, brought to Germany, and detained there. And the court found that legally irrelevant. Indeed, they pointed out that in Germany at the time, this is 1950, that there was still the danger of attacks by werewolves and others, and those security threats necessitated a rule that simply said habeas doesn't apply outside of the sovereign United States. Habeas has always been a manifestation of sovereignty over an area, and the moment that you start chipping away at that and saying, well, maybe, some detainees could be brought here or there, and you start making exceptions, then I think the whole thing starts to unravel. And that is not something federal courts have done for 200 years, recognize habeas in areas in which the United States is not sovereign. Here, I mean, I tell you, the notion of what is the theater of war, Professor Vladek's notion, bringing people to the battlefield and not to the battlefield, these are really hard, complicated questions that the executive, I think, is far better suited to do than a federal court. I kid you not. This is a quote from the argument in the district court made by the detainees' lawyers, the Afghan detainees' lawyers. She says, "The characterization of the situation as a full-blown military operation, I would submit, is not the situation at all in Afghanistan." Well, just open up the paper any day and see what our service members have to go through. I mean, and this is a really extraordinary situation that we're fighting in Afghanistan. And the notion that we're going to submit to federal courts what is and is not a battlefield, I think, is a tremendously dangerous notion. And then the further notion that we would give a federal court the ability to say, well, some detainees should get habeas corpus rights at Bagram Airfield, namely Professor Vladek's notion of who's brought to the battlefield, but not the others, because Judge Bates says if you're an Afghan citizen, you don't get habeas corpus rights, but if you are someone from Pakistan or somewhere else, you do. That whole notion of selective habeas, I think, is tremendously dangerous. I mean, how do you tell the government of Afghanistan, well, we're going to give habeas to everyone except your citizens? That strikes me as a very dangerous notion. I mean, we're there in partnership with them, and the notion that their citizens somehow would be disadvantaged in that process, I mean, maybe there's some sort of policy justification for such a rule that Congress might want to take up, but the notion that we're going to delegate that to federal courts, I think, is an enormously dangerous proposition.